Susie Locke on behalf of the petitioner Jared Hensley, who appears in my office.
David Morgan on behalf of the respondent, Tori Hensley, and she appears remotely, but she's involved with this hearing. She's not in my office.
All right, and we're scheduled today for hearing on a motion to modify residency and permanent parenting plan filed on behalf of petitioner. There is a motion to continuance that has been filed by Mr. Morgan, as well as a motion to dismiss. Some emails were exchanged regarding agreements to the continuance. It's my understanding that there were some negotiations, but Ms. Locke, you're objecting to the court continuing hearing on this motion?
Your Honor, we are objecting to the continuance that was requested by Mr. Morgan. Specifically, our concern is that mom is trying to avoid a hair follicle examination, which was requested in our motion. And we think is supported by the record and any additional argument that we would have today on that issue. Mr. Morgan is requesting a 45-day continuance. Mom has already had about 30 days. So we believe the basis of the continuance request is simply to avoid a hair follicle examination and a potential positive result. The parties have reached some agreement on communication, which supports in part our motion and related to their inability to communicate or mom's unwillingness to communicate with dad. They have converted to talking parents. And so I would hope that Mr. Morgan and I can file some agreement that talking parents would be used moving forward. But we would object to a continuance on the hair follicle issue alone today, Your Honor.
All right, thank you, Ms. Locke. And Mr. Morgan?
All right. Well, number one, we haven't had enough time, and I outlined everything in my motion to continue and my motion to dismiss. The motion to dismiss is really not up today. Ms. Locke says she needs 7 days. I guess our position is that we have something to file, a counter to their motion, and we have a motion of our own. We should get these filed. The court should set a date in January, look at everything together. If we need testimony at that time, take it all together. I can appear in person and we can do it all in one bunch. I don't think it's good today to take it piecemeal. Now, they want a test. Well, there's no allegations in their motion that supports a test. Why don't we just do it? Well, because you're going to hear in our submissions that there's been a lot of heavy-handed activity by father, a lot of bullying, and mom. Part of this divorce has said, I'm not going to be bullied and controlled by this man anymore. And she basically says, I'm going to put my foot down. I'm going to say no. But there has to be some basis in their motion. There is no basis whatsoever. There's no allegation of inappropriate parenting based on mind-altering substance. There's nothing. I mean, if you would allow a test at this point, you'd almost allow a test in every case when somebody says, we don't think their behavior is good. So I don't think there's a basis for a test at this time. After hearing arguments about everything, hearing testimony, the court should then make a decision if tests are appropriate. And one last thing to say is, with our submissions, you're going to know that even when father has the children overnight, he gets them up at 4:30, takes them to mother's house. They go into mother's house, and then she takes them to school. So this is a woman that takes their children to school every day. Every day she takes them to school, and every day she goes to work. She attends all their activities. To me, that is evidence of a highly functioning individual and no basis for a test at this time. So we're asking the court to continue this matter. Let us file our documents. They can file their response to dismiss. And if there's live testimony, we do it then. The court looks at everything and at that time decides if a test is truly necessary. Thank you.
All right, guys. Today we are going to step right into a heated courtroom battle where custody, control, and credibility are all on the line. From the very beginning, both sides clash over a motion to modify the parenting plan, but it quickly escalates into something much deeper. One side argues the continuance is just a delay tactic to avoid a hair follicle test, suggesting someone is trying to outrun potential results. The other side fires back, demanding more time and calling the accusations unsupported. What starts as a routine hearing instantly turns into a strategic chess match, where every delay, every objection, and every word is loaded with hidden intent and legal pressure building beneath the surface.
Thank you, Mr. Morgan.
May I respond, Your Honor?
Go ahead, Ms. Locke.
Judge, under KSA 233218, the court can order the physical examination of a party when there is a motion pending before the court for a change of custody or parenting time. Our motion does have sufficient factual allegations to support a test, and father will also submit to a test. Mom went to Colorado, left the kids alone for a significant period of time in the hotel by themselves. Mom's experienced significant weight loss. She's failed to maintain the children's expenses, despite father paying child support, so it's unclear where those funds are going. She recently has lied about expenses of the minor children and obligated dad to pay for things that were not actually expenses or 100% of an expense that should have been shared. So there are concerns and concerning behavior going on at mom's home that we think warrant an examination. And as I said, father will also submit to an examination. So it's not like we're making an accusation that is one-sided, but rather that both parents just establish for the court that they are clean, sober, and capable of parenting these children equally.
Could I respond briefly?
You may.
Okay. Expenses, that is a subjective decision. He says she didn't do it right. She says she did. You will read that in our submissions. Colorado, that is again subjective. And he obviously got this through the kids, which is inappropriate. So we have one instance of leaving the kids, in his opinion, too long. And that is all we have. That is not enough for a test now, Your Honor. Again, we ask that you continue it, look at everything together, and then make a decision. Thank you.
How old are the kids?
13 and 12.
12. Yes.
All right, I think there's a sufficient basis to grant the continuance, so the continuance will be granted. Regarding the test, I'm not seeing enough as we sit here today to warrant testing without hearing evidence on everything. So I'm going to deny a request for any hair follicle testing at this time. Angela, when can we get back? Do you think we need more than a couple hours to hear all of this?
I would say, let's just call it 2 hours or a half day. We would not go beyond a half day, that's for sure.
Do you agree, Ms. Locke?
Your Honor, we would like to be set earlier on the hair follicle piece. I know that the court is not inclined necessarily to bifurcate, but that's going to wait. If mom is positive and she's asking for a 45-day continuance, that is long enough since we filed and she was served our motion for her hair to potentially be clean. So we would like to be heard on the hair follicle issue and then be heard on the remaining issues in the motion before the 45-day mark. And for the entirety of the motion, I mean, I agree with Mr. Morgan that a half a day would be sufficient.
I think it'll just depend on when we can get it on the calendar, more so than setting a specific
And
45 days.
yeah, the reason, Your Honor, I'm not trying to deny this, but as you see, there's a little white hair on this man. I'm 68 and I'm going to go in for a right knee replacement on Friday. So I need at least 4 weeks. And what I don't want to do is have something on 4 weeks and say, well, I just can't do it. I got to appear in person. They tell me by 6 weeks I'm ready to go. So that's the reason why I am timing it this way.
Buckle up, guys. because this part shifts the entire tone of the hearing into a credibility war between both parents. The defense pushes hard, painting a picture of a stable and responsible mother who actively cares for the children, manages school routines, and maintains a structured life. But just as that narrative builds, the opposition counters with sharp allegations of manipulation, claiming bullying behavior and questioning the real motives behind the delays. The judge is left weighing two completely different realities, one of a devoted parent and another of alleged control and concealment. The tension rises as both sides dig in deeper, refusing to concede any ground, turning the courtroom into a psychological standoff.
Well, Angela, when do we have a half day or 3 hours in January?
January 22nd is our only available day at 1:15.
Your Honor, I am available January 22nd, but it sounds like Mr. Morgan is telling the court that he cannot be physically present in the courthouse by that time.
Do we have something the first week of February?
I have February 3rd at 9 o'clock.
Anything on the 4th, 5th, or 6th?
I have February 4th at 9 o'clock.
All right. We can do that.
Does the 4th work for you, Ms. Lott?
Your Honor, I start a 2-day trial on the 5th, but I would make the 4th work. And again, I understand the court's ruling, but we would ask for a hair follicle examination in advance of that. And if those results only need to be submitted to the court, that neither party gets to see them, but at least it was taken relative to the time that we were set for hearing on this matter, I think that that is beneficial to all parties to know what the status quo is.
The only thing about it is a one-time use. I don't know that's if that's all they have. I don't think the court would put a lot of weight on that. If it's a ongoing use, if we wait until February, it's still going to be there. So based on what I know, but I'm not an expert.
What is this a marijuana issue concern, Ms. Lott?
No.
No, Your Honor. We believe that there are other substances being used by mom.
Well, and like I said, if it's an ongoing problem, an issue, that's the only thing I think the court would really consider. It will still be positive as of February 4th or shortly thereafter.
But again, Your Honor, if we're going to try our motion on the 4th and the court makes decisions about parenting time and our motion, then there's no point to have a hair follicle examination at that time. We need the hair follicle examination for the court to make an informed decision about parenting time. That's why we requested it in our initial motion, so that the parties, and that's why the statute allows for the court to order the examination of the parties when a motion is pending.
I believe the court's already ruled that the court needs to hear a full argument on the testing before he can make a decision. This is not that long. It's not like 3 or 4 months. So this is 45 days. That's reasonable. Court can make a decision. If there's an habitual problem, it will show up.
Well, I'm not going to order testing at this time. We'll hear everything when we come back on the 4th of February, and then see where things stand.
Thank you.
And
All right, Mr.
just to be
Morgan,
clear,
could you
Judge,
analyze the court's order?
Yes, I will.
Go ahead, Ms. Locke.
is that hearing starting with Mr. Morgan's motion to dismiss, or are we actually having a hearing on our motion?
Well, I intend to we'll take up the motion to dismiss, and then depending on how that comes out, we'll take up the motion to modify.
All right, thank you. I'll do the order, Your Honor.
All right, anything else,
Nope.
Ms. Locke?
No.
Alright, guys, this is where things get even more intense as the accusations hit their peak. One side brings forward serious claims involving financial inconsistencies, questionable behavior, and even concerns about the children's welfare in specific situations. In response, the defense dismisses much of it as subjective interpretation and exaggeration, trying to pull the focus back to lack of solid proof. Both parents are even suggested for testing, raising the stakes dramatically and shifting the conversation from accusation to verification. The courtroom atmosphere becomes heavier, as the judge is now forced to separate emotional arguments from actual legal merit before making a decision that could significantly impact custody and parenting rights moving forward.